The American Bar Association and the abrogation of natural law. America's narrative is anything but the laws of nature's God. It's Babel. The more laws, the less justice. Marcus Tullius Cicero. A nation cannot survive treason from within. We, the people, have found a preponderance of evidence that the United States Supreme Court, the federal judiciary, the United States Congress, and the United States Senate, under the teaching and direction of the American Bar Association, also known as the minions of the New World Order, have systematically and covertly subverted the law of the land in violation of U.S.C. Title 18, Section 115, Subsection 2381, Treason, Subsection 2382, Misprision of Treason, Subsection 2383, Insurrection, Subsection 2384, Seditious Conspiracy, and Subsection 2385, advocating the overthrow of our government. We must end the American Bar Association, the devil's advocate. In 1729, Benjamin Franklin became the owner and publisher of a colonial newspaper, the Pennsylvania Gazette, which proved popular and to which he contributed much of the content. Franklin addressed many of the problems of the British rule in the colonies. In 1754, at a meeting of colonial representatives in Albany, New York, Franklin proposed a plan for uniting the colonies under a national Congress. Although his Albany plan was rejected, it helped lay the groundwork for the Articles of Confederation, which became the first Constitution of the United States when ratified in 1781. In 1750, the British Bar was established in the colonies to abrogate the common law and suppress the beginning of the American Rebellion instigated by Benjamin Franklin. The ABA has seized control of our government at every level through the deep state, whereas no decision is made, no law is passed, and no issue is resolved without the seditious bar orchestrated legislation intended to regulate our liberties and eventually abolish them, a necessity for their New World Order. The American Bar Association advocates, abets, advises, and teaches subversion of our republic, teaching the ABA taught attorneys that natural law has been abrogated via Federal Rule 2 that they authored. 18 U.S.C. subsection 2385. Whoever, with intent to cause an overthrow or destruction of any such government, prints, publishes, edits, issues, circulates, sells, distributes, or publicly displays any written or printed matter advocating, advising, or teaching the duty, necessary, desirability, or proprietary of overthrowing or destroying any government in the United States by force or violence, or attempts to do so, or whoever organizes or helps or attempts to organize any society, group, or assembly of persons who teach, advocate, or encourage the overthrow or destruction of any such government by force or violence, or becomes or is a member of or affiliates with any such society, group, or assembly of person, knowing the purpose thereof, shall be fined under this title or imprisoned not more than 20 years, or both, and shall be ineligible for employment by the United States or any department or agency thereof for 5 years next following his conviction. In 1819, our Founding Fathers ratified the 13th Amendment, which prevented British bar members from holding an office of trust. That was later removed by the ABA-controlled Congress in 1865 and replaced it with another. In 1822, Treaty of Verona, the British monarch and the Pope secretly agreed to undermine the American system of government via the Treaty of Verona. The British monarch breached the Treaty of Ghent, and both the Pope and the King secretly breached their trust as international trustees. They set out on a covert action and issued letters of marque and reprisal to the members of the bar and Jesuits, allowing them to act as foreign agents on American soil and as privateers, free to plunder America's economic, political, and judicial systems. 1871 Organic Act. The ABA-controlled Congress created a foreign state within a city, forming a municipality called the United States Incorporated, owned by foreign interests. 28 U.S.C. Code, subsection 3002, definition number 15. United States means a federal corporation. This transformed our unalienable rights to civil rights, our republic to a democracy, the United States to a corporation, and the laws of nature's God to civil and criminal laws, which have their roots in Babylon. This placed the United States under fiction of law, and as long as the people believe the fiction to be law, it is. In 1878, the American Bar Association was established. In an act of high treason, whereas 75 bar lawyers from 20 states and the District of Columbia met under the influence of the British Bar in Saratoga Springs, New York, to establish the ABA, the minions of the new order of the ages. Since that first meeting, the ABA, continuing the work of the British Bar, has worked in the shadows, infiltrating our governments, our courts, our churches, our institutions, and our media, demoralizing our children with fake education, all in an effort to expunge our common law and replace it with civil law, also known as Babylonian law, Justinian law, or Roman law. Today, with almost 500,000 bar members, 80,000 of them working in Washington, D.C., have perverted the rule of law, deprived we the sovereign people of a due process, and have supplanted our Article 3 courts with jurisdictions unknown. 1910 Conspiracy at Jekyll Island. In an act of high treason, 6 men, Nelson Altridge, Abraham Andrew, Henry Davidson, Arthur Sheldon, Frank Vanderlip, and Paul Warburg, met at the Jekyll Island Club off the coast of Georgia to write a plan to seize control of the nation's banking system. The meeting and its purpose were closely guarded secrets, and participants did not admit that the meeting occurred until 1930s. But the plan written on Jekyll Island laid a foundation for what would eventually be the Federal Reserve System, to be executed by the ABA-controlled Congress. (1913) Federal Reserve Act. The ABA-controlled Congress passed the unconstitutional Federal Reserve Banking Act, giving control of the American economy to a private corporation owned by foreign bankers, who answer to no one and regulate the value of worthless notes of debt called the dollar, robbed we the people of our gold, and bankrupt America. A conspiracy among Paul Warburg, Edward Mandel House, Woodrow Wilson, J.P. Morgan, Benjamin Strong, Otto Kahn, the Rockefeller family, the Rothschild family, and other European and American bankers, which resulted in the founding of the U.S. Federal Reserve System, which resulted in a takeover of the U.S. economy on behalf of the oligarchs. 1913 16th Amendment. The ABA-controlled Congress passed the unconstitutional, unratified 16th Amendments, which only appeared to create an income tax, an act of extortion, and a sponsor of debtors' prison via a slave tax, in direct violation of the Constitution, Article 1, Section 9, Clause 5, which states, "No captation or other direct tax shall be laid, unless in proportion to the census or numeration herein before directed to be taken." 1913 17th Amendment. The ABA-controlled Congress passed the unconstitutional, unratified 17th Amendment, which destroyed the check of balances in violation of the Constitution, Article 5, which states, "No state without its consent shall be deprived of its equal suffrage in the Senate." The 17th Amendment removed the state's representation in Washington, giving the Senate to the people who had already had representation in Congress, thereby depriving the state its equal suffrage. In 1914, the ABA-controlled Congress instigated World War I in order to distract the people and change the narrative to control the mindset of the people. In 1922, in an act of high treason, the New York County Association of the Criminal Bar announced that it planned a vigorous statewide campaign to abolish the grand jury institution. Former District Attorney Robert Elder called upon public prosecutors to take the initiative in replacing the inefficiency, ignorance, and traditional bias of grand jurors, and Judge Thomas Kane of New York supported the movement. Testifying before the Committee of the Law Enforcement of the American Bar Association, he observed that a judge or some other man learned in statute should participate in the grand jury hearing. In Minnesota, Attorney Paul J. Thompson urged his state to adopt the Wisconsin system of prosecution under the order of a district attorney. In 1922, Judge Roscoe Pound and Felix Frankfurter conducted a survey of criminal justice in Cleveland and added the weight of expert testimony to those who sought to eliminate the use of grand juries. Pound and Frankfurter reported that juries were inefficient and unnecessary since trial courts, politically driven by men, were quite capable of protecting Americans against executive tyranny. How's that working for us today? In 1933, the War's Power Act, also referred to as the War Powers Resolution, or the War Powers Resolution of 1973, is a federal law that governs the President's power to bring the U.S. into an armed conflict without first obtaining authorization from Congress as required under Article 1, Section 8, Clause 11. In 1934, the ABA-controlled Congress passed the Rules Enabling Act, whereas according to the Federal Judicial Center of Government Agency on September 16, 1938, pursuant to its fictional authority under repugnant Rules Enabling Act, stated, "The Supreme Court enacted uniform rules of procedure for the federal courts. Under the new rules, suits in equity and suits in common law were grouped together under the term civil action, claiming that rigid application of common law rules brought about injustice." In 1947, the ABA-controlled Congress initiated the National Police State Surveillance Grid. Today, the CIA is a private corporation which operates as a prostitute for global banking interest and does not represent the United States. In 1948, the ABA-controlled Congress created the United Nations on American soil, marking the beginning and the end of political sovereignty in the United States. In 1950, the 81st Congress investigated the Lawyers Guild and determined that the ABA organization was found and run by communists. Thus, any elected official that is a member of the ABA will only be loyal to the ABA and not the people. In 1962, the ABA-controlled Congress outlawed prayer in the classroom, marking the beginning of moral decay in America. In 1971, Southern Poverty Law Center. In acts of treason and lies, the Southern Poverty Law Center Intelligence Report, proclaimed to be the nation's preeminent periodical monitoring the radical right in the United States, is fueling all government agencies and police departments into believing that anyone that uses specific words, like militia, sovereign, oath keepers, constitution, patriots, and even founding fathers, to name just a few, are armed, radical, and dangerous cop killers, whose names are put onto terrorist watch lists. This agitation often causes police to overreact with excessive force and on a few occasions respond by SWAT when these words are used at a traffic stop. Much of the overreaction that fuels the police comes from that sprues forth the lies of the Southern Poverty Law Center to the unsuspecting law enforcement agencies and departments. The SPLC is the arm of the bar, whose purpose is to excite violence by federal agents and police upon we the sovereign people who are trying to make sense of this out-of-control federal judiciary and be free. In 2001, the ABA-controlled Congress passed the Patriot Act, and now today virtually every communication that we engage in is monitored. In 2002, the ABA-controlled Congress established the Department of Homeland Security, TSA, and FEMA, which during a national emergency controls every research, every asset, and even our freedom. In 2012, the ABA-controlled Congress, via Title 8 U.S.C. 1481, 1952, declared patriots willing to defend the Constitution to be terrorists. Rebuilding Babylon. The ABA-controlled Congress have flooded our courts with nearly 150 years of repugnant acts, statutes, and rules. All of the aforesaid destructive acts were possible because the people were not paying attention to what their government was doing. Today, the ABA holds a monopoly over the minds of the federal and state judiciaries and attorneys that practice law in our courts. There are 204 ABA-accredited law schools that are nationally accredited by the American Bar Association, and graduates of these schools may generally sit for the bar exam in any state. The ABA schools, in an act of treason, teach that in law, common law, is the body of law derived from judicial decisions of the court and similar tribunals, claiming that the defining characteristics of common law is that it arises as precedent. With almost 500,000 bar members, 80,000 of them are working in Washington, D.C., they have perverted the rule of law, deprived we, the sovereign citizens, of due process, and have supplanted our Article III courts with jurisdictions unknown. The ABA has seized control of our government at every level through the deep state, whereas no decision is made, no law is passed, and no issue is resolved without the seditious bar orchestrated legislation intended to regulate our liberties and eventually abolish them, a necessity for the New World Order. The American Bar Association advocates, abets, advises, and teaches subversion of our republic, teaching all ABA-taught attorneys that natural law has been abrogated via Federal Rule 2. The ABA is the devil's advocate. The American Bar Association must be annihilated. The only remedy to lawlessness is the law. Therefore, we the people have the power to nullify all these unconstitutional repugnant acts simply through self-educating and taking control of the judiciary through the committees of safety. We the people must force the reinstatement of the original 13th Amendment that was ratified by our founding fathers in 1818, which states, "If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind whatsoever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States, and shall be incapable of holding any office of trust or profit under them, or either of them." Bar lawyers have the title of high honor above the gentleman and above and below the knight, called esquire. Any judge who does not comply with his oath to the Constitution of the United States wars against that Constitution and engages in acts in violation of the supreme law of the land. The judge is engaged in acts of treason. Cooper v. Aaron. 18 U.S.C. subsection 2381. Whoever owing allegiance to the United States levies war against them or adheres to their enemy, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death. Governments derive their powers from the consent of the governed. Therefore, when a long train of abuses and usurpations express a design to bring the people under absolute despotism, it is their right, it is their duty to throw off such government and to provide new gods. You are the only solution. There is only one way we the people can save our republic. Only one. Committees of safety. Start a committee of safety in your county today. Ask yourself, what would the Founding Fathers do? Join our campaign for constitutional sheriffs. Go to nationallibertyalliance.org/county-sheriff-project. Join us to save our republic by learning the science of government by consent. Come to our weekly live open forums every Monday, 9 p.m. Eastern till midnight. Take our free civics course. Learn real American history. Take our government by consent course. Learn how to file a court case. Learn the difference between law and equity. Learn the Constitution. Learn natural law, also known as common law. Learn the true meaning of liberty. Learn how we the people can reinstate our natural law courts of justice. As Thomas Jefferson said, if a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be. An enlightened citizenry is indispensable for the proper functioning of a republic. Self-government is not possible unless the citizens are educated sufficiently to enable them to exercise oversight. It is therefore imperative that the nation see to it that a suitable education be provided for all its citizens. Educate and inform the whole mass of the people. They are the only sure reliance for the preservation of our liberty.